Case number 15-1-0897, Yongdan Nam et al. Versus Kwan J. Cho et al. On the motion for an order whether class action be maintained or in the alternative for permissive joinder of additional plaintiffs. Appearances, please.
Good morning, Your Honor. Dennis Jung on behalf of the plaintiffs.
Good morning.
Good morning, Your Honor. Chuck Troy and Neil Verbrogi on behalf of the defendants.
Good morning. Mr. Jung?
Your Honor, we've submitted a motion and several declarations and a reply memo. We believe that the criteria for Rule 23 class action has been met. We would suggest to the court that we have numerous proposed plaintiffs. At the moment, there are 225, and that number could double or even triple. The fact of the matter is that they're too numerous in order for any other alternative to be practicable. As far as the claims and defenses are concerned, they are all coextensive with each other. Essentially, all of our plaintiffs have the same argument. It's basically fraud. And the defenses that the defendants can raise are the defendants that are the defenses to the fraud. And so that it is clear that a class action would not cause any particular problem or issue for the court or for the defendants. As far as the individual or individuals to stand as representatives of the class, I propose Austin Kong. His case is well pled in the pleadings as of now, and the defenses to what Austin Kong has said are also in the pleadings that have been filed by the defendants. And so essentially everything that can be said, will be said, or could be said can be fairly adjudicated through Austin Kong or any of the other named plaintiffs in this lawsuit. We would ask the court to consider that this lawsuit is just beginning. We have another motion before the court for leave to file the first amended complaint. There's ample opportunity for whatever adjustments that need to be made. If there's any additional clarification, we certainly seek the guidance of the court as far as what also might need to be done in order to further clarify the class if necessary, the definitions, the procedures, or what have you. As we've tried to indicate, we're very open to suggestions from the court. We're not interested in any particular way of doing things, and so we are eagerly waiting to hear from the court as far as what might be possible. With respect to the fact that we're trying to skirt a filing fee, that is certainly not the case, Your Honor. The practicality would be that if the alternative to either the class action or the permissive joinder is we have to file another lawsuit. And we would argue or urge the court to consider that that is actually detrimental to everyone. It's not good for the defendants, it's certainly not good for us to have actions bifurcated. And then if we file a second lawsuit, then what are we going to do when we get another 200-something plaintiffs? Then we file a third lawsuit. If we get another 200-something plaintiffs, do we file a fourth lawsuit? The practicalities of this particular adjudication, this litigation, kind of lends itself to a Rule 23 class action. And with that, Your Honor, I'd ask the court to grant the motion.
Good morning, Your Honor. May it please the court. Your Honor, this is a sad and unfortunate case because ultimately this dispute is hindering and delaying the development of a Korean cultural center in Hawaii. This case fundamentally is about Plaintiff Austin Kang's efforts to have his dispute with the defendants play out in a court of public opinion in an effort to rehabilitate his lackluster tenure as president of TUCA. The defendants reject, deny, and dispute the accusations made against them. HKCC was formed legally, and on July 20, 2007, it was incorporated as a domestic nonprofit corporation. It's a legal 501c3 entity, and all donations were received legally. The defendants deny the fraud allegations against them, and the defendants intend to fight these baseless accusations here in a court of law. On the other hand, we expected Plaintiff Kang, and he proved us correct, that he wanted this case to be played out in a court of public opinion. My clients didn't contact the media to be here today. We suspect the instigator was Plaintiff Kang. This class action motion before the court today, we submit as another means whereby Plaintiff King can grandstand his baseless accusations to the media to try to shape public opinion in his favor. However, fortunately, this is not a court of public opinion. This is a court of law. And under the applicable law and procedure, this motion should be denied. As an initial matter, the defendants are concerned with the propriety of adding more potential plaintiffs to this lawsuit when the defendants have learned at least 4 of the presently named plaintiffs do not wish to pursue the lawsuit in defendants and may never have authorized plaintiff's counsel to proceed in their name. We reserve the right to conduct discovery into this matter if necessary. Plaintiff's counsel is correct. This case is in its early stages. And with that said, we do reserve the right to move to dismiss certain claims and plaintiffs or defendants from this action in the near future. As for the class certification portion of this motion, Your Honor, it's obvious to us that Plaintiff Kang seeks to round up potential new class plaintiffs to continue his strategy of intimidating the plaintiffs. But under the law, the plaintiffs have failed to meet their heavy burden of establishing all elements for a class action. The burden of proof is on the plaintiffs, not to establish 1 element, 2 elements, 3 elements, or 4. It's to establish each and every element to meet the class action requirements. The plaintiffs talk in generalities, talk about practicalities, but what they failed to do, Your Honor, is assess and address the technical requirements of Rule 23, i.e. the law and procedure that is applicable in this court of law. The court is to conduct a rigorous analysis into the requisites of Rule 23. And if the plaintiffs do not meet that, the class action cannot be granted. As for the numerosity requirement, plaintiffs points to a large number of potential plaintiffs, but what is lacking in their papers is any precise description of what this class is to be. Is it people that have donated to TUCA? Is it people that have donated to HKCC? Is it plaintiffs who have claims over $100? Plaintiffs have claims over $100. Is it plaintiffs who have donated labor, or time, or money, or any permutation of those 3 different variables? We don't know. And for counsel to suggest somehow that he would invite the suggestion of the court to craft his class for him, that's not the court's burden. It is the plaintiff's burden in each and every respect, on each and every element, in each and every prerequisite of a class action to meet that burden. It's not the court's role or burden to create a class. Plaintiff has failed to do that. Because the plaintiff hasn't even defined the class, it's impossible to determine the issue of numerosity. And if the issue of numerosity hasn't been met, this motion must be denied because that each and every element of the class must be met. The next element under Rule 23A2 is commonality.
If you want, for the record, Mr. Choi, to go through each of the elements, you may, but it's...
I would like to
clear.
walk through the elements, but go through them briefly, Your Honor, if the court will grant me that indulgence. I understand.
The plaintiffs have not met the standards for class certification.
Okay, I will move on to permissive joinder then, which is the other issue before the court then. And I just wanted to briefly say that the allegations of fraud are not a joint theory. Under the law of fraud, every plaintiff has to prove their own individual fraud accusations, and that clearly has not been met. But with that said, I'll move on to the issue of permissive joinder, which is the remaining issue in the motion. Your Honor, under the applicable procedural rule, Rule 20A, which governs the requirements for determining when permissive joinder is proper, the case law indicates that there's 2 tests. But further analysis of the case law actually indicates there's 3 elements of this test, and it bears out if you read the rule correctly. The first part is there's a right to relief arising out of the same transaction occurrence or series of transactions or occurrences. And this is commonly referred to as a transactional relatedness test. The second test is there must be a question of law or fact common to all the plaintiffs which will arise in the action, and that's the commonality test. The third requirement, which the case of In re Chokas has cited to, the asserted right to relief must be joint or several in the alternative against the defendants. So that requirement, which is not usually discussed in the cases, is clearly actually set forth in the text of the statute when you read the requirement to permissively join plaintiffs. They have to have a common joint right of relief. The plaintiffs in this case have failed to meet the transactional relatedness test and have failed to meet the joint relief test. There is no transactional relatedness here. For the same reasons we talked about, that each fraud allegation stands on its own, particularly in a case where you have a situation where individuals are alleging that they've been defrauded, which, by the way, my clients deny and dispute. But in that situation, you need a representation. You need to have some kind of proof of damages, and that requires individualized, particularized proof. To permissively join all these plaintiffs really is a recipe for ganging up, for complicating these proceedings, for making a gigantic mess out of one proceeding, and it's unfair to our clients. If an individual plaintiff wants to pursue a fraud claim, they have a right to put forth their own filing fee, file their own lawsuit, and pursue that. But what they're not allowed to do under the permissive joinder rule, under the transactional relatedness test, is to gather up 224 plaintiffs and jump into one lawsuit and overwhelm the defendants and gang up on them. Because the individual particularized proof required does not make them transaction related. And we've cited to you, Your Honor, this is not a case where an escrow company has fraudulently billed a group of people $25 that they shouldn't have billed them in an escrow closing. And you've got a set fraud that the escrow statement says $25 that for some fraudulent charge, and you've got a set damage. It's $25. This is a case where the alleged plaintiffs, the new plaintiffs, are saying, well, we were somehow told this or that. We don't know when they were told that. And that, by the way, is a basis for going to be a basis for motion to dismiss, which is the lack of particularity in the current pleadings. And by the way, we will also be reserving a right to move to dismiss for misjoinder some of the plaintiffs in the current case. But that aside, the point being is that these fraud allegations do not meet the transactional relatedness test.
The current allegations, it's conceivable that there could be a class action or permissive joinder with fraud claims if it was the same misrepresentation made.
If it was, but
And the same type of damage.
Right, but we believe that the issue of damage, we don't believe fits in what I talked about, the escrow case kind of paradigm. Whatever damages, which we deny, but if there were damages, they're going to be particularized. They're different. The representations we submit, we need to have some type of particularized allegations of fraud under Rule 9b to satisfy the standard, and we don't have that. So what we have here is a situation where under the Rule 20a requirements, there's the transactional relatedness test has not only been not met, it has been not even close to being met. And in fact, the converse is true, which is we expect after the motion for leave to amend issue gets resolved, which we don't have any particular objection to amending the complaint, we do reserve our right to move to dismiss the claims at the appropriate juncture when the responsive pleading is due. But we will actually be seeking also to dismiss the fraud plaintiffs from the body of the complaint, which is the TUCA fiduciary duty issues, because those issues are actually misjoined to the case under this transactional relatedness test. But I don't want to preview that too much. I just want to give the court an idea, kind of, because we are in the early stages of this case, where some of these preliminary initial pleading issues may shake out in the next month or two. But, Your Honor, I just want to close by saying that my clients categorically deny that they are liable in any way under the claims alleged against them, and there is no basis for a motion to add over 200 plaintiffs to do nothing but complicate and bully and intimidate my clients in an unfair proceeding. And, Your Honor, under the applicable law, we submit that the motion should be denied. Thank you.
we kind of agree with the court and with Mr. Verbruch that as far as the class definition is concerned, it's kind of loose right now. That was one of the problems that I alluded to in my reply memorandum. I tried to address that issue, but if the court wants additional particularity, I certainly would like to provide it. What we are saying is that there are people who donated to TUCA, and there are people who donated to HKC believing that HKCC was TUCA. All of those people are members of the class. And so that the class are comprised of individuals from the Korean community who made donations to HKCC, believing that HKCC was plaintiff TUCA. And so it doesn't matter whether the checks were written to the United Korean Association of Hawaii or whether the checks were written to Hawaii Korean Cultural Center. It doesn't matter. These are plaintiffs who believe that they were donating to plaintiff TUCA. And so that we want to make sure that the court understands that that is our, one of the pillars of what we determine an appropriate class to be comprised. As far as the amount is concerned, I think you can see that I've struggled with that myself. And my earlier formulation, I think, is totally arbitrary, whether to say that, you know, an amount of greater than $100, amount less than $100. I think that what I'm suggesting at the moment is any amount. And I think that certainly that is a consideration. I am sensitive to the Rule 9 issues that Mr. Verbruch has alluded to, and I've been thinking about that myself. One of the problems here is that this fraud was pervasive from almost the inception of the Hawaii Korean Cultural Center under the plaintiff Sungap Saw back in 2006, all the way up until such time as the defendant Young-hae Kim left as the president of plaintiff TUCA. And it was always a case where there was almost continuous fundraising throughout that period. And so that it's not that there was one fraud that occurred on one particular day, but it was a continuous fraud. Now perhaps what Mr. Verbruch is suggesting under Rule 9 is I have to say...
Mr. Choi.
No. He's Mr. Verbruch, actually.
Oh, yeah, I'm sorry.
Yeah, the guy on the left is Mr.
Court's
Choi.
mistake, I'm sorry.
I know, the way he introduced himself
you
to
know,
the
I
court.
introduced myself.
Yeah, he said Chuck Choi and Mr. Yeah. But anyway, so in other words, Your Honor, as far as the timing under Rule 9 is concerned, that I thought that Mr. Verbruch was going to suggest that. And so actually, I did want to alert the court to the fact that that is actually the way the fraud was perpetrated. And so it was a continuous fraud. And so that whenever the term Hawaii Korean Cultural Center was used, that was part of the fraud. It was as if I had a First Hawaiian Bank in my office and I was First Hawaiian Bank. It's not that I was defrauding people on this day as opposed to that day. I'm defrauding people on every day that I am operating a First Hawaiian Bank out of my office, because I'm not First Hawaiian Bank. So the thing is, I suppose if that has to be part of the class definition as well, to satisfy Rule 23 as well as Rule 9, then I suppose we could do that as well. I tried to suggest in my initial motion that this was not something that we planned, contrary to what is being suggested, that this issue was thrown upon us. Actually, you know, in hindsight, I'm very happy that they threw it at us. It actually, to me, helps the case. As I suggested in my reply memorandum, as far as the fraud is concerned, Plaintiff TUCA cannot be the victim of a fraud. It's the individuals who are the victims of the fraud. It's everybody who took money out of their wallet and gave it to Plaintiff TUCA. Whether the check is written out to Hawaii Korean Cultural Center or it's written out to the United Korean Association of Hawaii is immaterial. As long as the people believed, reasonably believed, that they were giving to Plaintiff TUCA. And why shouldn't they reasonably believe that? Because the defendant, Young-hae Kim, was the president of Plaintiff TUCA. And Dr. Kwan Jae Cho was the co-chair of Plaintiff TUCA's committee. And so that in this case, that is the essence of the fraud. And we've said that many times in the pleadings, but I think that that's important to note even in oral argument here, in a sense that in order to establish the class, that is what the problem was, and that's what causes these people to believe that they have a cause of action. Now, I would question whether Mr. Verbruch is correct, that if a person donated $100, then he has, the only way that he can address his claim is to file a complaint in court as an individual and pay whatever the filing fee is in order to make his complaint of $100. In terms of this particular case, I think that there's no issue that we meet the jurisdictional requirement of the court, that this case is appropriately brought in circuit court. But it shouldn't matter, Your Honor, whether the person gave $1,000, $2,000, $20,000, or $100. In order to get to that $650,000, thousands of donations were made to Plaintiff Tuka. And so in that sense, it is rather appropriate that this matter be conceptualized within a Rule 23. To the extent that we, having grappled with the class definition, have not really gotten over the threshold, we're asking for guidance from the court, and perhaps the court to take this under consideration, or to offer us an opportunity to file a supplemental memorandum to better define the definition of the class along the lines of Rule 23. We would argue that it would be a matter of justice and judicial economy to allow this matter to proceed as a class action on this basis. We understand that Rule 23 is a very serious procedural rule, and it's there for a reason. And I think that Rule 23 is necessary to support the substantive issues that are raised in this case, and I think it can. And we certainly ask for an opportunity to comply fully with the requirements of Rule 23. And that's what we would say in response to what Mr. Verbruch had to say.
Based upon the court's review of the matters that have been submitted, the court denies the motion without prejudice. Plaintiffs have not adequately demonstrated the 4 prerequisite elements required under HRCP Rule 23 to certify a class. It is a rigorous analysis that is required. Defendants have put forth in their memorandum in opposition the requirements for class certification and demonstrated how they have not been met thus far with respect to this action. Plaintiff must establish the 4 requisites for class certification under Rule 23A, and then further demonstrate the presence of a suitable situation for maintaining a class action under the criteria set forth in at least one of the subdivisions under Rule 23B. And the motion that was filed is lacking with respect to compliance or analysis with respect to the requirements of maintaining a class action. And further, the motion does not demonstrate compliance with the requirements under Rule 20 for permissive joinder.
Your Honor, do I understand what the court said earlier in response to what Mr. Verbruch says, that it's a matter of the way this motion was crafted, but in terms of the framework, the practicality, the court is not taking the position that a case like this, where fraud is alleged, that fraud can be the basis of a Rule 23.
The question was directed to that particular issue, and that it may be possible for a class action or permissive joinder to be based on an allegation of fraud, but it would certainly have to be put forth before the court with the requisite specificity and particularity and commonality and common issues of law and fact, and meet all the requirements for class certifications.
I wonder if maybe I could ask you some other questions so that we can
Your Honor, I don't think it's appropriate for plaintiff's counsel to be asking the court for advisory opinions. One, it's...
I agree, and to the extent that you've asked the court for guidance, it's not the court's rule. I only responded that, yes, the court had questioned defense counsel with respect to that one issue
unfair.
Okay, I take that. I suppose that that's all I needed to hear from the court as far as that's concerned. And I understand it's without prejudice, so I can refile when I get it all right.
Motion is denied without prejudice.
Very good, thank you.
If you'll prepare the order.
I will, Your Honor. Thank you.
Court will be in recess.
All rise.